process and start building a case. And answering questions, which is really what an investigation is about, way before you get to a prosecutor. Because sometimes you never get to the prosecutor. Your job is to go where the evidence leads you. And there were things about this case from the very beginning that just seemed like questions that needed to be answered. And one of them was, that gun was purchased 4 days earlier by James Crumbly, who was the same person who was at the school that day. This is information they're learning immediately. They do a search warrant for the house and for phones, and they find out a lot of information. You saw the video of the shooting. There's a reason we tell the media they have to turn their cameras off. We don't want those images out there. We don't want them to be on the internet. We don't want to encourage another school shooter. And we don't take any pleasure in showing it to you. But it's our job to know the truth and look at it and not look away. He told you how each of those kids died. Hannah was hit immediately after he left the bathroom. You saw the image and it was described to you. Madison Baldwin didn't run. She crouched down. There was a door 4 feet from her. And she put her hands over her head. And he walked right up to her and he shot her at close range in the head. Tate was shot. I talked about that shot he took as he was coming in the door. He had his headphones on. He didn't even know what was going on. And Justin Schilling was shot in the bathroom after several minutes of being in there. It wasn't immediately. Shooter went into the bathroom, stayed there. Justin knew the shooter was there. And there was another student in there as well. You saw him running, Keegan. And he ran after James Crumbly's son shot Justin Schilling, execution style. Defendant's son had access to and the use of this gun. It was preventable and it was foreseeable. You heard during jury selection, and you heard during opening, and if my prediction is you're going to hear it again, that this could be you. This could be any of us. This is what this is their defense, that this could be you if you let your kid drive a car or leave with a sharp object. This couldn't be everybody. This couldn't be the person that takes their kid hunting. This couldn't be the person that buys a gun for their child to use, for their minor child, for their use. That doesn't create a criminal charge, ladies and gentlemen. It couldn't happen simply because you purchased a firearm or simply because you let your kid drive a car. Beware of the claim that this could be you. Beware. It is not the case that finding James Crumbly guilty of gross negligence would result in a criminal charge for every parent who doesn't know what their child is doing at all times. And it is not the case that he was faced with the same normal challenges as parents that we all go through and suddenly found himself in a courtroom being charged with involuntary manslaughter. It is just not the case, and the evidence shows it. In June, the Derringer and the Caltech were purchased by James Crumbly. We know that Caltech was left out, unsecured, with ammo. Why do we know that? you saw that picture and video and the one he sent to his friend, and you saw the text that accompanied. But before we get to that, this is an image from the video that you saw. It was 12:30 at night. That is his cat, Dexter. That is the shooter's cat. That magazine is loaded, and it was shoved on a table to load it, not a proper or safe way to handle a firearm. And there is a round in the chamber, and the safety is off because red means dead, and Special Agent Brandon told you that. Even if James Crumbley was standing next to his son, that would still be an extremely dangerous way to handle a firearm. But we do know what happened, because he told his friend when he texted it to him. My dad left it out, so I thought, why not? This is precisely the reason there's a legal duty in the state of Michigan to prevent your kid from harming himself or somebody else. All I need is my 9mm pistol, which I currently am begging my dad for. This is from his journal. First off, I got my gun. It's a Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I have access to the gun and the ammo. Then we have defendant's own statements. James Crumbley said it's a substation. James responded when asked where the gun was. It was hidden in our armoire in the case, and the bullets were hidden in a completely different spot underneath some jeans. Here's what he doesn't say. Never claims it was locked, never says it was inaccessible to his son, and again, never says or expresses any surprise on how his son got a hold of it. We know he took him to the range. We showed you videos and images of that. In fact, 8 times we know that happened.
Prosecutor McDonald there bringing up the text messages, talking about what James knew about the location of that gun. We have to squeeze in a break. We're going to get you back in for more closing arguments on the other side. Don't go anywhere.
Tonight on Closing Arguments, another dramatic day in the school shooter dad trial. Our legal experts break down the strategies we're seeing from both sides as this trial begins to wind down. Plus, the latest developments in the heartbreaking case of Madeline Soto. We'll tell you what new information we've learned surrounding the disappearance and death of the Florida teenager, what new evidence has come to light, and what's next in the investigation.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
Let's go back to Michigan for more closing arguments in the school shooter dad trial. The defendant is James Crumbley.
Prosecutors allege that he didn't take those steps that were needed to prevent his son Ethan from killing 4 students at Oxford High School back in 2021.
Let's get back into the courtroom together. Now the prosecutor is giving the final parts of their closing argument in front of this jury.
We know that throughout June, July, August, September, October, by November, when he begged his dad for the 9mm, and he actually did buy it for him, now he's at the point where he can instruct other people. It's James Crumbley's son that knows more about guns and when he takes his mom to the range. And how did he learn? James Crumbley taught him. He didn't take himself to the range with his dad. This is the shooter, 2 days, 1 day after the gun was purchased for him. He's packing it up. What don't you see? The cable lock. It's not even in a case anymore. And there it is. That's the cable lock that was provided that day with the pamphlet and with the gun. Just the day before. It's already out of the case. Here's where the other 2 guns were found in that bedroom, in defendant's bedroom, interlocking a safe, in the TV stand. The code was 000. The important thing is that the SIG could not fit into that gun safe. Could not fit it. It's impossible. But the other important thing is you're hearing a claim that James Crumbley didn't think that he had to lock his weapon up. Okay. It's not about whether you locked the weapon. It's about whether you made it secure. And we already know he felt the need and understood his duty to lock the other two. Special Agent Brandon read to you the lines if he had opened it up, if he had read it, if he had believed it, those deaths could have been prevented. If he had just read it and just did the simplest of things. This is the crime scene. There were 32 shots fired that day by James Crumbley's son. How do we know this was foreseeable? The shooter says in his journal, I have zero help for my mental problems, and it's I'm during jury selection and opening about kids exaggerate to their friends. This is his journal. He's not sending it to a friend. He's expressing his state, which was desperate because he needed help. I want help, but my parents don't listen to me, so I can't get any help. My parents won't listen to me about help or a therapist. I can't even say with a straight face or even find a way to explain the rationale behind a 15-year-old that desperate writing that in a journal because he was exaggerating or lying. We have the text between James Crumbley's son and his friend about exactly what he wrote about in the journal. He hears people talking to someone in the distance. I actually told my dad, asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up. Again, teenagers exaggerating to make themselves look better, to impress. None of these text messages to his friend make him look better. None of them make him look impressive. They just make him look desperate and sad and wanting help. I'm having bad insomnia and paranoia. I need help. I was thinking I could call 911 so I could go to the hospital. This was in April. But then my parents would be really pissed. I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. But this time I'm going to tell them about the voices. And then on April 5th, like I am mentally and physically dying. What did James Crumbley know? He knew the family dog had died. A grandmother had just died. His son's only friend, the one person he had any social contact with, abruptly leaving, can't even text him. Knew his son was completely isolated. Knew he had looked up bullets the day before. Knew he was upset the night before. Knew he had been watching videos that morning, violent videos. And then he sees that drawing. He sees that drawing that morning when he goes to the school, and what does it say? It says, help me. How many times does this kid have to say it? He says it in his journal, he says it to his friend, and what is he saying? I asked my parents, I asked my dad. And then if that isn't enough, he writes the words, help me, on a piece of paper. And his parents, James Crumbley, is called to the school to see it. And what does he say? He says, we gotta go to work. He describes his son as a perfect kid, never gets in trouble. Well, you know, if you have a perfect kid that never gets in trouble, being called to the school abruptly that day and asked to come and saying your kid needs help is about 100 out of 10 in terms of how troubling it is for a parent, if it's that unusual. He knows his son is proficient with guns because 4 days earlier, he purchased that weapon for him. This is James Crumbley's son on the morning of the shooting, November 30th, being dropped off like every day by James Crumbley. And here's the worksheet. The thoughts won't stop. Help me. You have a picture of someone bleeding with bullet holes. You have a picture of the exact gun. It says blood everywhere. My life is useless. The world is dead. This is the worksheet James Crumbley looked at when it was texted to him. This is the worksheet he sat and looked at when he sat in that counselor's office. Those are the words he was reading when his wife said, "We can't do that today. We have to work." And he said nothing. And he leaves with a piece of paper with the names to call. This is what he was looking at. And there's the piece of paper. It took just one tragically small measure of ordinary care to avoid 4 deaths. James Crumbley failed to use ordinary care, which could have prevented the death of these 4 kids. Didn't stop at home to check to see where that gun was. Even though you can't take him, which we know he could have driven around with him. He could have not done any DoorDash run until Jennifer comes back from work. He could have gone to see where that gun was. We know that in his DoorDashing, he was minutes away from 11 o'clock to 1 o'clock. He didn't search or ask to see the backpack. Never thought then to say, "Hey, can I talk to you out in the hall?" Or, "Hey, where's that gun?" Didn't ask his son where that gun was. Didn't check the journal.
All right, we need to slip in a commercial break as we approach the top of the hour. More closings ahead. I'm done, but you will shepherd
Good
on.
afternoon. We are headed into these closing arguments. Our thanks to Ashley Bargainquest for her insight. What will the defense do after this? Welcome back to Court TV Live. I'm Julia Janae. Thanks so much for following along with us this afternoon. Madison Baldwin, Hannah St. Juliana, Tate Meyer, and Justin Schilling. These are the 4 victims that this case is about that we are following in Michigan. And the fate of defendant James Crumbley is soon going to be in the hands of a jury as the second of 2 historic trials begins to wind down. James Crumbley and his wife Jennifer, they're the parents of a school shooter who's charged. They are charged for their child's actions, something we haven't seen before. Jennifer was found guilty earlier this year, last month, on 4 counts of involuntary manslaughter, 1 for each of those victims in the 2021 Oxford High School shooting. Jennifer chose to testify in her own defense during her trial, but this morning, James notified the court that he would remain silent. That's his right in front of this jury. Could this make a difference in a guilty or not guilty verdict? We're soon going to find out. But first, let's get you back into court for the remainder of the state's closing argument.
Didn't lock and secure ammunition, didn't lock or secure the gun, didn't take his son home, didn't take him to get this care that a counselor's telling you he needs, didn't say, "We bought him a gun 4 days ago as an early Christmas present," and didn't tell the school much relevant information at all, and Sean Hopkins told you that. He also didn't disclose any of the instances that you were shown throughout this trial. That there was a message in March about him doing something stupid. Jennifer Crumbley was concerned about it. James was always home. Is he home yet? Is he home yet? Is he home yet? Leave me alone, I have to work. He's fine, is what he says. The incident about giving him melatonin and him being worked up, didn't tell him that he'd asked him for help and asked to go to the doctor, told him to suck it up. Didn't say about the friend and how it was his only person he ever had any social contact with, that there were multiple guns in the home, that he was begging for a 9mm. James Crumley never even shot that gun. He didn't fire it once. He had it, he purchased it on Friday. On Saturday, he was gone all day doing DoorDash. On Sunday, he was gone all day doing DoorDash. And that he wants you to believe he had this secure hiding spot. What, it was a hiding spot for one day? We know it wasn't there on Saturday. We have the shooter taking pictures of it. And we know the cable lock isn't around. And we know Jennifer leaves. He's alone with this gun. Didn't say that it was identical to the one in the drawing. Didn't say he bought 50 rounds to take home. Expensive rounds to use at a range. This is the DoorDash information from 11 o'clock to 1 o'clock and all of the times he passed that house. He was within minutes. We know that he was absolutely concerned about this worksheet until after the shooting in the substation where he says it was doodling. We also know that not once on any of his devices did we find any searches or information he was trying to get about firearm safety or how to make sure a minor doesn't get a hold of it, laws, any of it, until after the shooting. We know that at 10:37, he arrives at school. His son leaves at 10:52. They're gone by 10:53. At 11, he logs on to DoorDash. He completes 4 orders. He tells us in the 911 call and at the substation, he saw cop cars. We know that 12:51, the shooting starts, and we start to see students and parents, we heard, arrive at the Meijer. They're being told by dispatch that's where their unification time is. James drops off his last order at 1:01. The email comes out from the school at 1:09. At 1:11, James is in the Meijer parking lot. It's unclear exactly why. He calls his wife for 57 seconds. That's the call lasts 57 seconds. He's on the phone with her for 10 minutes and 19 seconds. He gets home at 1:20. During that call, she texts her boss, the gun is gone and so are the bullets. So we know that by 1:23, both of them had knowledge about that. He calls her again, 1:30 to 1:33, another 3 minutes, and finally calls 911 at 1:34. There were 1,800 students in Oxford High School. There was one parent who suspected their son was the school shooter. And it was James Crumley. You know what that's called? It's called foreseeability. That's what that's called.
What's the location of your emergency?
Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to high school. I have a missing gun at my house. I need an officer to come to my house right away, please.
Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation right now.
I understand that. There's a missing gun there. I have a missing gun, and my son is at the school. And we had to go meet with the counselor this morning because of something that he wrote on a test paper, and then I went down and I saw a bunch of cops going somewhere, and I made sure that I wanted to get to the hospital to see if someone was going to high school, and then somebody told me that there was an active shooter, and then I raced home just to find out. And I think my son took the gun. I don't know if it's him. I don't know what's going on. What you
Put your hold for just a second, okay? I have to talk to McKinnon and see if I can do anything for you, okay? Or put your hold.
Thank you.
Okay, good.
You just heard this. I have a missing gun. My son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper. And then I saw cops going somewhere. I wanted to go to the school, see what was going on. I heard about the active shooter, and I raced home just to find out. We don't have to discover or argue about whether or not he was put on notice that something was really, really wrong. He says it. He says it. He calls and he says, because of this meeting at the school and because I have a gun, I went home to look for it when he heard about the shooting. So the question of whether or not that did concern him, it's not a question. We know it concerned him because he said it. And then at the substation, and this is what he said, and somebody said there was an active shooter, I immediately freaked out because the situation. And after I saw all the cops, after I found it was an active shooter that went on this morning, and after what went on this morning, what's he talking about? He's talking about the meeting and the words on the paper. It says, help me, blood everywhere, with a picture of the gun he bought him. So I raced home and I found the gun missing. We went into detail about what James Crumbley and his wife did after they thought they might be charged with a crime. And the evidence clearly shows what they didn't do. They did not turn themselves in. They did not make sure that they were in the area. They withdrew $6,000 and they went to Detroit and turned the car around so the license plate is not facing, and didn't go out and buy that stuff themselves. They sent somebody else. And lastly, defendant conflicts his own statements. At the substation, the drawing was doodling. When he received it from his wife, he's concerned, my God, WTF. He says at the substation, I immediately raced home and found the gun, and that's when I called you. I called you guys right away. It was 14 minutes after he got home. You think your kid has this gun, you know he does. You know he's really upset, you know the words he wrote, you suspect he's the shooter, and you wait 14 minutes to call 911? He doesn't know when the shooting started or when it ended. I think he owed something to the parents and the kids in that school to at least try, once he did figure out that the gun was gone, which any reasonable person would have known. But why lie and say you call right away? You called after a 10-minute conversation with your wife. At the substation, he's a perfect kid, doesn't get into trouble, yet he was looking up bullets. And yet they were called to the school, and the drawing, he doesn't say that, or what the drawing was really about. It's a downplaying situation, and then he says the gun was hidden. And again, never once, I don't know how he got it. Never once says that. James Crumbley had concerns that day. He knew something was wrong. He said it in his own words. And we know that because of what was on the drawing, and we know that because we know what his response was when he received the drawing. He kept those concerns private that morning. But he didn't just fail to inform the school. He failed to act. James Crumbley failed his son in a tragic way. You're not going to hear me say that's not true. But he didn't just fail his son. He failed Hannah. He failed Madison. He failed Tate. And he failed Justin. He failed to perform his legal duty to prevent these kids from being killed. And he failed their parents, too. And I ask that you find him guilty. Thank you.
Thank you, Prosecutor. Ms. Lynn?
Yes, Your Honor.
Prosecution, they're ending their closing arguments with the images of those 4 young victims, those 4 faces that this jury, they want to keep in mind to get justice for them in a variety of ways. We've seen now this final 3rd person is on trial, James Crumbley. Let's bring in our guest who's standing by. Trial attorney and host of Once Upon a Crime in Hollywood, Kelly Hyman, is standing by. Kelly, it's good to see you. Weigh in on the prosecution's case, the way they laid it out in these closing arguments, and how effective you think it is as we get ready to hear what the defense will say in response.
That was a powerful closing argument. So she went time by time, minute by minute, and laid out the case and shown what he should have done and what he could have done. And the key thing is whether the fact that this was foreseeable. That's definitely going to be key. Was this foreseeable that his son was going to go and kill these people, or was it not foreseeable? Did he have this knowledge? What did he did? The state did a great job because, as you know, they have the burden to prove every single element of the crime.
And we'll be hearing from them again with a rebuttal after the defense is done. But I thought she was able to really bring that energy and passion when she talked about the words on that worksheet where he wrote, "Help me," people dying, blood everywhere. She also brought up, Kelly, that 911 call that James Crumbley made about 14 minutes after he saw that the gun was missing in their home. Is this something that the defense can turn around to help him, to say that he didn't know what was happening, he was trying to figure it out, or is it one of those things where it's damned if you do, damned if you don't? If he had acted like he didn't know the entire time, we may still be at the same place.
That's a good point. Potentially they could potentially argue the fact that he had no knowledge that this was not foreseeable and that when he got home, the gun was missing and he had no idea. So that goes to what he knew, and that's definitely going to be key. I also think that the defense are going to try and poke holes at the state's case to try and have some reasonable doubt that in fact that it wasn't his fault, that it was not foreseeable. I think that's definitely going to be key in the state's closing, the defense closing argument.
We should be hearing that very soon from Mary L. Lehman, who is the attorney for James Crumbley. Let's squeeze in a break, get you back into the courtroom. You won't miss a moment of these closing arguments. Stay with us.
The first parents in America to be charged in a mass school shooting.
Involuntary manslaughter and 4 counts of it.
The gun recovered from the shooter was the same gun that was purchased by his father.
Jennifer was found guilty.
Who is responsible for storing the gun?
Now the school shooter's father is set to stand trial.
My husband is.
The school shooter dad trial. Live coverage today on Court TV.
Welcome back to We're going to get you back to Michigan. Welcome back to Court TV Live. I'm Julia Janae. We are watching closely the closing arguments that are happening in the school shooter dad trial. Prosecutors say that James Crumbley ignored his son's pleas for help and even bought him the gun that he would later use in the 2021 Oxford High School shooting. But the defense says that James was unaware that his son had access to the firearm, that it wasn't foreseeable what he was about to do that fateful day. Let's get you into the courtroom now. The defense's closing argument is just starting.
There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings in particular have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James Crumbley and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that that day had on them. Multiple people told you what that day was like. They told you what they felt, they told you what they saw, and they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hannah St. Juliana, Madison Baldwin, Tate Meir, and Justin Schilling. As you've seen throughout this trial, the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others and that James acted in a grossly negligent manner or breached a duty that he owed to other people despite having no information at the time. You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021 and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, if there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. When it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence, a little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have one or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty. You can believe that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't, because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt. Also, if James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that, but you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon. Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission.
Marielle Lehman showing that passion right out the gate for the defense closing argument. We have to squeeze in a break. We'll get you right back in. You won't miss a moment. Welcome back to Court TV Live. Before we get you back into the courtroom in Michigan, we do have some developments out of Idaho that we want to keep you abreast of in the case against accused killer Bryan Kohberger. On Tuesday, the Idaho Supreme Court issued a ruling denying the defense's request to toss out the murder charges. They've had a lot of questions and criticism of the way that grand jury indictment came down. This comes after the lawyers for Kohberger asked the state's highest court to step in on a previous decision that was made by the trial judge overseeing the case, but no luck for Kohberger. Those charges, they're staying put. The case is going forward. Trial is being looked at for 2025. And we'll, of course, bring you the updates on this case as they develop, but we do want to get you back into the courtroom in Michigan, where the defense is giving their closing argument in the school shooter dad trial against James Crumbley. We've hit the pause button, so let's go back in right where we left off.
Because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've seen him. Judge Matthews instructed you at the beginning, James is wearing headphones. James is hard of hearing. He needs a hearing-assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
Your Honor, I hate objecting in a closing, but that is not evidence, and that her client didn't testify, and so it's just not evidence what he was doing, and it's just not. And his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the time that his son made that video. He knew that James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyak told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm. Was it unsupervised? We don't know. Was it supervised? We don't know. We don't know. So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time. Instead, you saw texts between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw James and his son, and saw no concerns. Not worried, didn't hear anything, didn't see anything, wasn't made aware of anything, no concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation that he had talked to his son that morning, told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son, right in front of Sean Hopkins' desk, sat next to him, went over the piece of the math assignment with him, the drawings, what was on there, that he was caring, that he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication at all, just that one may exist. And again, in that meeting, there were no comments, whether either before James got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me and I need you to tell them. That didn't happen. Instead, Mr. Hopkins testified that he had concerns about the level of although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he'd had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework.
We do have to step aside for a quick break, but let's bring in trial attorney Kelly Hyman, who's watching along with us. Kelly, I have to ask you about this headphones defense. Our viewers have been asking for days now why James Crumbley has those things over his ears. We knew they were headphones. We know it's usually to help hear. I didn't expect to hear it in closing arguments. Your take?
Yes, exactly. So the fact that she was using that in the closing arguments and the state stood up and said basically that this is not evidence, because a closing argument, you're supposed to recap all the evidence of what the evidence showed, and then the fact that the evidence didn't show this. So that's why the prosecutor got up and basically said, hey, there was no evidence about this. They can't speak on something like that during the closing. But we have to state that defendant's counsel is doing a great job. She is really telling a story compassionately and really advocating for her client that he didn't know, that there was no evidence to show that he didn't know, that he didn't have this knowledge. And that is definitely going to be key. What did he know? Was he able to stop this? Did he have this knowledge? Was this foreseeable? Definitely something key for the jury when they deliberate on this case.
Absolutely, all about foreseeability. Let's squeeze in that break. We'll get you back inside of the courtroom for more of those closing arguments after this.
Tonight on Closing Arguments, another dramatic day in the school shooter dad trial. Our legal experts break down the strategies we're seeing from both sides as this trial begins to wind down. Plus, the latest developments in the heartbreaking case of Madeline Soto. We'll tell you what new information we've learned surrounding the disappearance and death of the Florida teenager, what new evidence has come to light, and what's next in the investigation.
Closing Arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
Welcome back to Court TV Live. We want to get you back inside of that courtroom in Michigan where defendant James Crumbley faces up to 60 years in prison if a jury finds him guilty on those 4 counts of involuntary manslaughter. Right now, the defense attorney, Marielle Lehman, is giving the closing argument. Let's go back into court.
His homework. So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed 1 or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself. More than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, my son was a great kid. I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that. But Christy Gibson Marshall also said that James's son was a good kid. Christy said that her testimony was that she was standing in the hallway. She had spotted the shooter coming down the hall with a firearm, with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand and an injured student in front of her, smelling cap gun. She didn't think that was right. Even in those moments. Going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they believed that James and his wife were going to get their son help. That they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't. Sean Hopkins and Nick Ejak testified that they didn't ask if there were guns in the home. They didn't ask because they weren't concerned that James's son was a danger to anyone. Despite the information and the concerns that they had, they made decisions with the information that they had at the time and based on their education and training, which we can all probably agree a school counselor and a dean of students has more education and training than the average parent. And even with all of that and the experience with teenagers and what they had in front of him, they still didn't believe that there was a reason to be concerned that James's son was a danger to anyone. In fact, they didn't even feel that he was in immediate danger to himself, because if they had, they testified they would have done things differently. James worked. You heard the testimony. He left the school at approximately 10:57, and if you want, you can go back through the exhibits, and logged on to the app for DoorDash and started working within 3 minutes. The prosecution is focusing on James not going home in the time from leaving the school and when the shooting started. Why would he? He didn't know. He didn't know what was going on with his son. He didn't know what his son was planning. He didn't know that his son knew where the guns were. And he didn't know that his son had somehow obtained access to those guns. Or a gun. He didn't know. So why would he go home? There was no reason to. You heard about James's actions following learning of the school shooting, or following the school shooting. You heard that he went to the Meijer, which was the reunification point on Ray Road. You heard that he saw the police lights, he saw multiple police cars, he followed them. He actually tried to go to the high school first and he couldn't, so he went to the Meijer. And it was there that he learned that there was a shooting at the school, that there was an active shooter at the school. There's evidence and exhibits showing James's movements while at the Meyer. He was there for approximately 6 to 7 minutes. In that time, he texted his son. You can see that on exhibit 375. He called his son to see if his son was okay. He texted his son again. He called his wife. He talked to his wife for about a minute, and he left the school. Then he called his son 2 more times. 2 more times in less than a minute to find out if his son was okay. He talked to his wife again for about 10 minutes. You saw a text during that phone call from James's wife to one of her coworkers where she says that their son was the school shooter. Contrary to Detective Lieutenant Willis's testimony that James said his son was the school shooter, he didn't. James didn't say that. You heard the 911 call a few minutes ago. That's not what James said. James called 911 at 1:34 p.m. and said that his son was a student at Oxford High School, and that after he'd learned about the school shooting, that James had gone home, he found the gun and bullets missing. He didn't know if his son took it, that he didn't know if it was him. And if you recall, Nick Ejak and Sean Hopkins both testified that even during the shooting at the school, even after the meeting that morning with James's son and James and his wife, even in those moments, they did not suspect that James's son was the school shooter. Sean Hopkins testified that he didn't even think that it was James's son who was the school shooter until after he checked attendance, after the shooting had ended, and after James's son had been arrested.
The defense there drawing the attention to these jurors of what happened outside of that school, not inside. Our thanks to Kelly Hyman for joining us this hour. We reached the top of the hour, so we do have to get in a break. My time is up. But coming up, Judge Ashley Wilcott is picking up our coverage. Hey, Judge Ashley.
Hi, Julie Janae. Always great to see you. Of course, Court TV is going to stay on these closing arguments to bring you the rest of the defense, and then we'll have the rebuttal by the state in the school shooter dad trial. Stay with us, Court TV. Welcome back to Court TV Live. I'm Judge Ashley Wilcott, honored to be with you for the next 3 hours. The fate of defendant James Crumbley will soon be in the hands of a jury as the second of 2 historic trials begins to wind down today in Michigan. James Crumbley and his wife Jennifer are the first parents of a school shooter to be charged for their child's actions. Jennifer, the mother, was found guilty earlier this year on 4 counts of involuntary manslaughter, 1 for each of the victims in the 2021 Oxford High School shooting. Now it will soon be up to a jury to decide the fate of James, the father. Let's go back in now for more of the defense's closing argument. We hit the pause button so you haven't missed a moment.
You've heard that a couple of times from James. And you can listen to that call yourself. It's Exhibit 154. You can almost hear, as James is talking to the dispatcher, how he's looking back at what had happened that morning and trying to piece things together and figure out what's going on. You heard from James 2 more times within hours of the shooting at Oxford High School, once at the substation and once while in the backseat of a patrol car. At the substation, James learned that his son was the school shooter, that he was not injured or anything, that he was in fact the school shooter. You heard James say he was freaking out. He asked for a water. His mouth was dry. He was freaking out. James was emotional. I believe that Detective Sergeant Bryan testified that James was sobbing, that he was crying. You can watch it. You can see how James was reacting in that interview. Detective Bryan said that James was forthcoming, that he was willing to speak with them, even after James's wife suggested, maybe we should get a lawyer. Maybe we should stop talking. James said, no. Let's keep talking. I want to keep talking. It's okay. We can keep talking. And he does. He told the police how many guns were in the home, where they were located, that the handgun that was used by James's son in the shooting was a 9mm Sig Sauer. He mispronounced it. We've all heard that. That it was hidden in an armoire. No one in that interview, neither of those two law enforcement officers in that interview said, well, you shouldn't have had it there. Was it locked? How did your son get it? You didn't hear those questions. You heard James tell the police that the handgun was stored unloaded and that the ammunition was stored somewhere else. It was stored separately, under some jeans. Again, those two officers didn't say, well, you shouldn't have done that. That wasn't right. Well, you did that the wrong way. Well, that was really irresponsible of you, Mr. Crumbly. They didn't say any of that. The police didn't ask if the gun was locked or in a safe. James clearly told them that that 9mm was hidden. And the police moved on. James talked about what a great kid his son was, about his mediocre grades, but overall he didn't get in any trouble. You watched as James saw his son for the first time after that school shooting. It was a very brief encounter. And you saw as James was leaving that he repeatedly told his son he loved him. Ladies and gentlemen, you can watch that for yourself. It is Exhibit 301. He repeatedly told his son he loved him. And then after, as he walks back into the first interview room, you can hear him audibly crying, sobbing at what was going on. And what does he say? He asks the police if he can find out where his son is going to be. And they say, yes, the court will tell you. In that interview, you also heard James Crumbly say, I wish we had taken him home. In hindsight, looking back, I wish we had taken him home. James had no knowledge that his son had access to any of the firearm, any of the handguns in the home. You saw his son's own words sometime after November 27th of 2021 and before November 30th of 2021. And we know that because in Exhibit 359 on page 22, his son specifically writes 9mm. And we know that there was no 9mm in that home prior to November 26th of 2021. We know that James's son went to the shooting range on November 27th of 2021 with his mom. So we know that that had to have been written sometime between November 27th and November 30th of 2021. We talked quite a bit about this during jury selection. Most, if not all of you, agreed that there's a difference between having access and giving access. We talked about car examples. We talked about the responsibility in different scenarios, a parent's responsibility in different scenarios. This case is like the first car scenario, where the child takes the car without the parents knowing, takes it out and something happens. This is the first scenario. This isn't the second scenario, where the parents might have suspected that their child might do something. This wasn't the third scenario, where James knew his son was going to do something and just handed him whatever it was he was going to do it with and said, here, take it. This is the first scenario, where James Crumbly had no idea what his son was capable of. He had no idea what his son was planning, and he had absolutely no idea that his son had access to those firearms. Also, as an aside, if it really were his son's gun, why was it hidden in James's bedroom? If it really were, why was it hidden? Not only in the bedroom, but in a location that James's son was not aware of. Sometime before November 26th of 2021, James's son wrote this in that journal notebook that was found. Exhibit 359, page 15. We know that it was before November 26th of 2021 because of some of the other statements that are around that journal entry, which you can look at if you'd like, but they reference a 9mm and a .22 caliber. And we know that there was not a 9mm in the house before November 26th of 2021. And even here, I don't know where my dad hid it, is a reference to .22 Caltech. Even before November 26th of 2021, well before November 30th of 2021, James Crumbley's son didn't know where those firearms were. He told you he didn't, in his own words, in his own handwriting, which was verified by law enforcement. There's no evidence that James Crumbley had reason to believe his son would hurt anybody. I went over this a few minutes ago. Christy Gibson Marshall's testimony was that she had known James Crumbley and his son since approximately 4th grade. She told a story about James emailing her and asking about getting his son's report card or grades or something along those lines, and she responded and said, "Give him a hug for me." She testified about everything she saw, heard, and felt on November 30th of 2021. And as I said, she talked about seeing the shooter walking toward her with a gun in their hand. That as the shooter got closer, she recognized that it was James's son. And in those moments, she thought to herself, this can't be right. He's always been such a sweet kid. She was in such disbelief that was his son that she even tried to talk to him. As he's walking through the school with a firearm in his hand, she is trying to talk to him because she just can't believe that James's son was the shooter. And it was when he wouldn't respond that she realized it must be him. ATF agent Brandon testified there were no laws governing the storage of firearms. We went over this a little while ago. We talked about the various ways that you can store firearms. I outlined a few of them. He testified that people store firearms unloaded and unlocked, which in and of itself is not irresponsible or dangerous in 2021. Not putting a gun in a safe or using a trigger lock alone does not mean that that person is irresponsible. Now, ATF agent Brandon gave you his opinion about what he saw on that math homework. That opinion was given within the last couple of days. And with all due respect to Agent Brandon, his opinion on what he saw is irrelevant. It doesn't matter in this case. What matters in this case is what people thought that math homework showed on November 30th of 2021. And those people weren't concerned. They didn't see what Agent Brandon saw. They saw images that weren't concerning, that are common, that other kids write and draw about. The concern was that he was sad and needed to talk to someone. On November 26th of 2021, we saw evidence and heard testimony that James Crumbley went and bought the Sig Sauer at the gun store. James had been to that gun store on multiple occasions. We heard that testimony from Ms. Back, who told you that she recognized him because he'd been there before. There were at least 2 other handgun purchases from that store, which we heard about, the .22 Derringer and the .22 Keltec. James indicated, per Ms. Back, that he'd been looking at the Sig Sauer for a few days, or a while. She couldn't really remember which one it was. She testified to both. That he knew that that was the one he wanted to purchase. So he did. You also heard Agent Brandon testify about the cable lock that was found in that Sig Sauer gun case. That the sleeve that the cable lock came in was essentially in pristine condition, that the keys were still inside the lock. Now, if you recall, that Sig Sauer was used. James bought that used. That sleeve being in pristine condition means that the person before him didn't use it either. You also heard that James did not purchase ammunition on November 26th of 2021 or at any point prior to November 30th of 2021 for that 9mm. There were purchases for ammunition when he would go to the gun range for the .22s, but James didn't purchase 9mm ammunition before November 30th of 2021. Cammie Back told you that she had, that James didn't even talk to his son while they were standing there in the gun store. She didn't see any of that. She had no reason to believe that James was buying that gun for anyone but himself. And if she had, she couldn't have sold it. So obviously she didn't think that. On November 3rd of 2021, James Crumbley and his wife left a hotel that they had been staying in. Well, they had stayed in a couple different hotels, but they left a hotel that they had stayed in after the shooting on November 30th. You heard some testimony, or you heard some information that their residence had been made public, or there was media there, or there were things going on, and you can imagine. I mean, you all can imagine what that was like in the days following the shooting at Oxford High School. You heard Agent Brandon testify today that James and his wife were in and out of that building throughout the day on December 3rd of 2021. You heard testimony yesterday from Detective Willis that they arrived at approximately 11 a.m. and that they were there for the day. They were obviously arrested later that night. But you heard testimony that Luke Kirtley saw at least James Crumbley. You heard that James and Jennifer had both gone in and out of the building. Jennifer is his wife, had both gone in and out of the building throughout the day, various times to smoke, walk out to the car. Sometimes one of them went, sometimes both of them went. December 3rd, 2021 was a Friday.
We need to take a break. Let's hit the pause button. When we come back, we'll get you the remainder of the defense's closing argument up next.
The first parents in America to be charged in a mass school shooting.
Jennifer was found guilty. Now the school shooter's father is set to stand trial.
The school shooter dad trial. Live coverage today on Court TV.
Tonight on Closing Arguments, another dramatic day in the school shooter dad trial. Our legal experts break down the strategies we're seeing from both sides as this trial begins to wind down.
Closing Arguments tonight at 8/7 Central on Court TV.
Breaking news, the sentencing date for armorer Hannah Gutierrez has been set for April 15th of this year. Gutierrez was found guilty of involuntary manslaughter just last week. A jury found that her actions on the Rust movie set led to the fatal shooting of cinematographer Helena Hutchins. She faces now up to 18 months behind bars. Now let's get you back to Michigan for the school shooter dad trial. Let's go back to court now for the remainder of the defense's closing argument.
You heard that there were at least 14 cigarette butts found near their vehicle. You saw over 300 exhibits during this trial. You heard testimony from over a dozen witnesses. None of them told you that James knew what his son was planning. None of them told you that James knew that his son was a danger to anyone. None of them told you that James knew that his son knew where those firearms were hidden. None of them told you that James knew that his son had somehow obtained access to the firearms that he had been hiding. None of them told you that because on November 30th of 2021, James Crumbley had no knowledge about any of that. He had no knowledge and he had no reason to suspect what his son was planning to do later that morning on November 30th of 2021. Now, every time I do a trial, I have somebody tell me that they think of a reasonable doubt that I may not have thought of. So, think of your own. You don't have to agree with all of mine. You don't have to agree with any of mine. You can come up with your own reasonable doubt. Based on the evidence that you've seen, the testimony that you've heard, your collective memories, you can come up with your own. You're not limited to what I've come up with, and you can certainly reach your own reasonable doubt conclusions on your own. And as you deliberate, think about the things you did not hear during this trial. Think about the things that you were told you would hear during the opening statements, that you would hear how the shooter gained access to that gun. You didn't hear that. That you will hear from school officials regarding their concerns about the math worksheet. You heard that they were concerned about sadness, not about danger to others. That you will hear that the need for immediate parental intervention was necessary. You didn't hear that. In fact, you heard the opposite. You heard that Sean Hopkins said that James and his wife, that they wanted James and his wife to have their son talk to someone or to at least make arrangements within 48 hours. No one testified that immediate parental intervention was necessary on November 30th of 2021 during the meeting with Sean Hopkins and Nick Ejak. No one testified that there was a need for immediate intervention of any kind, discipline, mental health, or otherwise. You did not hear testimony detailing how the shooter obtained access to the SIG Sauer. You just saw in his journal that he said he had access, but you don't know how that happened. No one testified that the shooter knew that there was any sort of code to open the gun safe. There's been some talk about the code.